going on since Thanksgiving, realistically. Actually, since the beginning, I would say at least 6 months that I've evidence to that point.
Okay, so let's get what we're here for today clear, okay? There was an order issued, so just follow me, all right? There was an order issued for you to undergo a competency to stand trial.
Well, I would consider.
There was an order, whether you agree or not, there was an order.
Well, I mean, here's the thing. I consider that to be a legal order.
Ross, this is not going to work if we interrupt here. Let me explain to you why you're here. Then you can say what you want to say. That was an order. You didn't comply with it. And there was a show cause hearing for you not complying with it. That's what started this whole thing. Then
I object to that 100%. I was trying to get to that at the point when I believe the officer from examiner was here. I did not deny anything. I was 100% willing to go. It was her lack of communication. She was saying things that were untrue.
Do you think you need a competency evaluation?
No, I 100% don't think I need a competency evaluation. If you take this, you see the sequence of events that started this. See, I beat competency on the floor by, I believe it was your former head prosecutor here, Fakano, if I'm not mistaken, when he forced himself into my case when I was at a Class B misdemeanor status. See, he kind of said that, beat on the floor, destroyed. That was November 10th. Now, I beat it, which was signed on the 5th, gave it to me on the 2nd, and then it was passed back to you guys. Can you look at this? And it was passed back. Can you take this evidence and submit it to the judge?
Not until you keep quiet, we can talk about it.
Listen, then on the 15th, you guys said that I put the motion for competency evaluation. That I did. Then right after, it had an acknowledgement to waiver of rights and notice of revocation order. And then at which point, when I called the 28th and then uncovered those things, it seemed like you were put in the case, and then you requested the competency evaluation. So it looks like you guys are rejecting my evidence, which clearly lays out why that happened. I did not.
You don't even have a clue what you're talking about.
Well, when you won't look at something and see.
Well, I'll be more than happy to look at it. I just want to make sure we both understand why.
Well, I mean, I don't think we're on the same thing at all. Because see, the show cause hearing was not about me defaulting. Maybe that's what you guys say. You didn't want to get to it or talk to it. Maybe the chief forensic examiner, I believe, might have been there. Now, see, I had no problem seeing her within her time frame. She refused to communicate with me. Of course, I did have a problem because Halls never showed any cause at all, and we're way past that 90-day window. It's not my fault if the state doesn't show cause. Now, we're like at 4 months from when it was signed, but really this started on November 10th, and I can show you paperwork that they've been on this since the very beginning of communicating with community council.
You just answer my question. You can sit here and go on and on and on and on and on all afternoon. I have no idea what you're talking about. Or we can have a conversation and try to resolve this. What do you want to do?
What do I want to do? Obviously, I don't
want to
want.
have a conversation and try to resolve this, or do you want to keep going on and I don't know what you're talking about?
Well, I mean, now you say that the show of cause hearing. When you say that the show of cause hearing was because basically I was delinquent, I consider that
That's
incorrect.
what was scheduled, Mr. Ross.
Well, see, the thing is, I would consider the state delinquent. No, objection. I would consider the state delinquent. Here's why. Now, when the office of the examiner put that forward, she never put it forward to me. The court never gave it to me. I wasn't given that to the 28th, and that was put forward on the 5th. So how would you know if I was delinquent or not? Because you guys completely destroyed due process and have left me out of the situation. Now, if I'm trying to contact the office of the forensic examiner frantically to make this appointment, and she refused to communicate with me, it seems to me that you guys are trying to force a lawyer on me. Now, see, the last, the show of cause hearing, it had bail conditions on it, which I found very weird. This is very weird. So I get a letter that shows up, and so you can imagine how flustered I am with this situation. And then you say that. Why has there not been a show of cause hearing at all, just for a show of cause on the competency evaluation? Why, when I ask the office of the examiner, can you give me one single word what Hall says and why they're trying to have me committed, or whatever it is, or say that I'm incompetent, basically retarded? They can't give me a single thing.
That's not what it means. You don't even understand what it means.
Oh, I do understand what it means. I know that's one step off from a lot of things, and with their behavior and the way that they're pushing paperwork any way they want, it seems pretty close. So I do know what it means. I know that I'm one step off from a whole world of hurt. It's the thing, if you look here.
Competency evaluation mean? What is it for?
To see if I'm legally competent to stand trial.
And what do they have to show to make that determination?
Would I can rationally understand the proceedings before me?
Very good. understand the charges before you, and can participate in your defense. Do you think, and let's stop there, do you think you understand the charges before you?
I 100% understand the charges before.
What are they?
They're call harassment, 2 charges of alleged call harassment by way of the phone on the town of Hollis, the police department, and the town hall, with no communicative purpose, no communicative visit with the purpose
All
to
right,
annoy alleged
you
reports.
certainly understand the charges against you. Secondly, do you understand what the role of everyone is to do? Do you have what Officer Corrado's job is, what my job is, and your job is?
Obviously, I fully understand that.
Just give me your rundown of how you want, what do you understand everybody to be? It may be a very simplistic question.
Well, I mean, first of all, I am the pro se defense at this point, right? He is obviously the prosecutor. You were supposed to be the unbiased judiciary judge. Unbiased, and really stressing that word unbiased. And it's just very simple. He comes forward, he presents information, I present information, maybe. He calls people up, question them, I do. There's a very precise sequence this thing
Who has to
happens.
prove the charge against you, you or him?
He does.
And what's the standard beyond what?
Unreasonable doubt. But now we turn to some weird preponderance of evidence stuff that's really taking this to a complete different realm, way past his 9 days. That's the case law he used in this. Things that we produced through a preponderance of evidence and flipped it the other way around. I don't enjoy that case law. So we've gone way beyond the simple little thing that you're talking about. We've stepped into a whole other
that's my
league right
point.
now.
You don't understand that. We haven't. So listening to you today, it's pretty clear to me. Well, one, you understand the charge against you. You understand what his role is, what my role is, and what your role is. I don't think you're incompetent to stand trial. I'm not going to make you have the evaluation. So you win. You're not going to have to do the evaluation. Okay? So we're going to schedule it for trial. That's the final, that's the end. We're going to have a trial. The trial is he has to present evidence. You can cross-examine witnesses. You can test any evidence they bring against you. And I'll make a decision at the end.
Well, I mean, I want Rule 21A1 to kind of get away from Hollis and all that. See, I wanted a speed trial, because you have to realize that these things are burdensome. You have to realize that they've been doing this through my whole life. This is my high school bully right here.
When you leave here today, you're going to have a trial.
Yeah, and I would like that to be a little bit out, at least 60 to 90 days, but realistically, I mean, normally I would say I want to sit here 90 days after this whole crap you guys pulled. No, here's the thing.
Officer Corrado, you all right with 90 days?
That's fine, Judge.
I mean, I'm just going to Rule 21A1. Now, I wanted a speedy trial, a speedy jury trial by Rule 21A1. Now, we all know that trials, they're very burdensome. They take a lot out
asked for
of
90 days. You
Yeah.
want 90 days?
Oh, sure.
Okay. So
Just to
90
make
days.
sure that I get that Rule
You've got 90
21A1.
days. 90 days, we'll have a trial. That will end the whole thing. One or the other will end everything. Okay?
Well, I mean, if you guys think so, I just thought it was the Rule 21A jury trial would make this big shit show, then I was gonna go bring things like the jury standard, appeal, try to make that
So
common
you
law case law, so
want
that's how I
to
get
just
down.
do the Rule 21?
Sure, but I'll produce that, by documentation, I'll get that into you guys, you know, I'll make sure that happens, that's what I want. See, I want to only do one trial, which was the jury trial, then move on to appeals, and not deal with any of this crap. Look what you just did, let's talk about undue stress, look what you guys just did to me. I can show you paperwork right now that he was just trying to push it through and have me committed. I can show you other stuff when he has people calling up my mom, saying that my mom wants to have me committed. That's why I can't have a lawyer, because he's
Okay.
convincing everybody
You do not have to
that I'm
have,
supposed to be
you do
committed.
not have to have the competency evaluation. We're going to schedule for trial. Before you leave here today, we're going to do it at your request in 90 days. In the meantime, if you want to waive the trial, do the Rule 21, be my guest.
Well, you gotta realize there's some big issues
Then we'll
here.
go-
See,
then
there's
we'll
a
go to
2-year
jury.
period on complaints, and they do so much official impression.
That's it, right?
And intimidation, I have got my complaints through. What if my complaints are in the national prosecution with false arrest, right? Because that's what happened last time with Pulse. That was false arrest. Now, if we go on further, it was destruction of evidence in 911 footage, kind of like the dispatch that are pointing the finger on me now. Of course, that's here. That's the National Prosecution Office. It was also prosecutorial misconduct, just for trying to push it all forward where there's clear destruction of evidence. Because I got all that from my last lawyer, Brandon D. Ross, and I thought it was great until you guys got to him, and you kind of flipped it on him this far. He was an amazing lawyer up until that point. Amazing guy.
Hold on. Don't leave yet, Randy. Hold on.
July 20th.
July 20th, all right with you?
So what's the date today?
Today is
April, May,
17th.
June, July, sure.
Okay.
And I need to recuperate from all this undue stress. This is the massive amounts of undue stress. And I have all up here showing that he's been trying trying to brutally have me committed for 6
Calm
months?
down, don't lose it, there's no reason to. There's no reason to. You don't have to have the competency evaluation, you obviously know what's going on.
Dude, but obviously he knew that the whole time. Obviously everybody knew that the whole time.
I
And
didn't.
there was a big cover-up. There was a huge cover-up. Listen, I got bail at Nashua. You know why? Because Nashua had to give me bail before releasing me to Hollis. Because they were going to have me committed that day. They've been at this for 2.3 years.
The hearing's over.
No, listen, do you know what?
It's over.
Do you just want to know what happened? What swipe hit the hornet's nest? Do you want to know? Do you want to know the embezzlement at Hollis Brookline High School?
No, I
And
don't.
know what swipe hit the hornet's nest?
Randy, have a nice day, calm down, please.
Sure, but I think Hope Hollis knows we're going to get to that embezzlement. It's very clear. And Hollis is all about their state and federal funding when it comes to demonstrating this law.